Good afternoon and welcome to the webinar. My name is Catherine Gorter. You're joining us for the Legal Aid Queensland CLE webinar this afternoon. I'd like to start by acknowledging the traditional owners on the lands on which we all meet, which we all come from today. We pay our respects to their elders, laws, customs and creation spirits. We recognise that these lands have always been places of ceremony, teaching, research and learning, and we acknowledge the important role that First Nations people play in our community and improving our legal system. So yes, welcome to today's webinar. The topic today is therapeutic pathways within the criminal courts, looking at the Queensland Drug and Alcohol Court, or QDAC, and CourtLink. We've got quite a few presenters with us here today. Joining us from Legal Aid is Penny Williams, a principal lawyer and head of our QDAC team. We've got Laura Rouse, another principal lawyer in our criminal law services team. We'll also be joined by Kim McNally, who's the operations manager, referral and support services, including the CourtLink program. And we also have Will Thirl from DJAG joining us as well for any questions that may be asked about the QDAC program. I just have a little bit of housekeeping to run through at the start of the webinar before we kick off. So just to advise, this webinar is being recorded. We will be putting the recording on our YouTube channel after the webinar has finished, and that will be available in a few days' time. You'll also be able to access that through our Community Legal Education resource page on the Legal Aid Queensland website. If you have any audio or technical issues during this webinar, please go to the GoToWebinar customer support page on the GoToWebinar website. This webinar is a 1-hour webinar. The presentation of the speakers will last for approximately 40 minutes, and we're trying to allocate about 20 minutes for questions at the end. So please, if you have any questions during the webinar, type them in the question box in the control panel for your GoToWebinar screen, and we'll get those and we'll shoot those through to the presenters at the end of the webinar in the questions section. There is a handout that you can download as well. It's a copy of the PowerPoint slides. So go to the handout section in the tab open on your screen and you can download a copy of today's slides. We've got a couple of polls we'd like to run through just to get a sense of who's joining us today. So the first one is asking what region that you work in. I'll just launch that poll now so you can answer. So the options are you joining us from South East Queensland, Far North Queensland, Regional Queensland, or outside of Queensland? Couple more seconds for that one. Okay, I'll close that one off now and share those results with you. So what we can see is 64% of you are from South East Queensland, 14% from Far North, 19% from Regional and 2% from outside of Queensland. That's great to know. The next poll is asking about what your role is. So the options here are you a support or community worker, a financial counsellor, social worker, lawyer, or other? So I'll give you a few seconds to put your answer in. Couple more seconds. Great. I'll just share those results now. So 37% are support or community workers. We've got a fair few in the other category. We've got another large group of lawyers, some social workers and some financial counsellors joining us today, so that's great. And so our last poll, I'll just launch this one for you now. It's, have you referred clients to QDAC or CourtLink before? So the options are yes, frequently, sometimes, rarely, never, or I don't know what these programs are. So once again, I'll give you a little bit of time to answer that. Great. And it looks like a lot of people are saying never or I don't know what these programs are. So this information is really useful for our presenters to know, and they can frame the information they share to you and your information needs. So that's great. Now I'll just go back to our presentation. So a brief outline of what we're going to cover today. Our presenters are going to talk about what the CourtLink and QDAC programs involve, how therapeutic programs like these can help offenders improve their circumstances, eligibility requirements for these programs and referral processes, some positive outcomes that are being achieved for program participants, how your agency can be involved, and then we'll be wrapping up with a Q&A section at the end as discussed. And now I'm going to hand over to our first presenter, Penny Williams, who's going to talk about the Queensland Drug and Alcohol Court. Now just excuse me while I slide off screen and introduce Penny. Thank you.
Okay, I just wanted to cover, because obviously the court that I mainly work in is the Queensland Drug and Alcohol Court. So I wanted to give you all just some information and an overview of that court before Laura speaks about CourtLink, and we have some representatives from the Department of Justice and the Attorney General who also work in those courts, who will also provide some information to you. So as you can see from the first slide, just to give you an overview, the Drug and Alcohol Court is an intensive and targeted treatment support program for adult offenders. So that's one of the first criteria. It's for adult offenders, where severe drug and or alcohol use is the core component of crime. So it has to have contributed to the person's or the applicant's offending. It doesn't have to be the primary or only reason for the offending, but it does have to be a contributing factor to the offending. With QDAC, the sentences involve a sentence of imprisonment of up to 4 years. So it is in Magistrates Court that the Drug and Alcohol Court sits. And if for those of you not familiar with the courts in Queensland, we have the Magistrates Court for adults, Magistrates Court, then the District Court, then the Supreme Court. Most people commence their, after arrest, commence their matters in the Magistrates Court, and magistrates can typically sentence people for a large number of offences of up to 3 years imprisonment. So Drug Court has a special provision to be able to give people sentences of up to 4 years imprisonment, so we can capture some people who might be a little bit more high level offending and otherwise just miss out on being able to access the Drug and Alcohol Court. Now that sentence of imprisonment is then suspended for a minimum of 2 years, because the government, after doing some research and consultation, looked at a lot of factors, and that 2 years was settled as being a good amount of time to enable people to access and really take the advantages and benefits of alcohol and drug counselling and education, and to assist those people to then try and have some long-term benefits, and not just benefits during the order, but that they carry on after the program as well. So you can see on point 2 of the slide there, completion of a 2-year treatment program to address the underlying issues involving, and that 2-year program involves regular court appearances, random alcohol and drug testing, housing assistance and other supports if they're necessary, legal representation and close engagement with a magistrate, rewards and sanctions to encourage program engagement, with the aim of the Drug and Alcohol Court being to reduce an offender's substance use disorder and decrease their risk of reoffending. And clearly that will benefit not just them, but also have the on-flow effect to assisting the community at large. So one can see just from, I guess, looking at that 2-year treatment program, you know, there's a lot of commitments that are involved, and for people who have been using drugs and alcohol for even just a couple of years, and some people we have who come to the Drug and Alcohol Court have used for a large number of years, this is a real change in their routine and a real change in how they've lived life for a long period of time. So although perhaps to you and I that might seem fairly achievable, it does take a lot of the participants that we have in drug court quite a number of months to be able to get into a routine and understand all the supports that they have and be able to really benefit from those supports. And particularly, I think in this day and age, we'd all agree that the housing assistance has probably become now more of a real underlying factor that needs to be addressed, and we're trying to work with a lot of non-government agencies to assist people in that respect. But the housing crisis is a big issue. So just to give you an overview of what QDAC, that's the acronym we use. If you see it on other slides, that's the Queensland Drug and Alcohol Court, so QDAC. What its aims and impact. So engagement in QDAC can help offenders, which we call participants on the program, to improve communications and relations with Department of Child Safety. So we have a large number of participants who have had children that have a Department of Child Safety order, and certainly we've seen, even for people who've not graduated but perhaps who have managed to show some stabilisation through the order, that they've had increased access and contact with their children. Counselling for grief and loss and other issues, and we also work, I guess, side by side with their engagement. Some people have the National Redress Scheme as an issue that it works alongside drug court. We don't address those issues in drug court, but of course through the alternative avenues. But again, it's just part of the overall looking at a person in a holistic way. Improve their mental health stability, compliance with medical treatment, improvements in general health issues, improve family relationships, and assist them with education and employment. So it's again just showing you that the drug court is trying to look at a person and say, how can we help you, not just with your drug and alcohol issue, but obviously the other things that underlie and also affect you in your daily living. Now, one of the things that some of you may be aware of, and it certainly is a hot topic with lawyers and others in the legal system, is that the Queensland Drug and Alcohol Court is based in Brisbane, and it's based out of the Brisbane Magistrates Court. So one of, I guess, the restrictions is that to be eligible for QDAC, you must be living or intend to live in the Brisbane Magistrates District. And you'll see there's a map on the screen, and it gives you this sort of boundary which the Drug and Alcohol Court works within. But again, because of what I've just spoken about with the housing crisis, I guess there has been a recognition, certainly recently, and I'm sure Will correct me if I'm wrong, that there has been some flexibility taken in terms of the strict boundary lines given the housing crisis and the lack of affordable housing in the Brisbane area. So while certainly you might look at those eligibility requirements and think, oh, I've got a patient or a person I support in the community agency I'm in, and they've talked about criminal offending, but they live at Browns Plains, so no drug court for them. That is certainly something where you could make an inquiry to us at Legal Aid, or even to DJAG on the court's website. There's their contact details also, because it may be that that person could be someone that could commence with assistance through the drug court and perhaps move further in, or it may be they have very good transport lines to be able to access Brisbane. You can see on the screen there just the other criteria. I've already mentioned about being an adult, and I've already mentioned about the severe substance use. So just I mentioned before about the court's website. Now that is probably, out of anything that maybe you take away from today, the best thing to take away or remember is the information that I'm providing to you can be accessed through the Queensland Court's website. And certainly if we receive any inquiries, I know either at DJAG or in Legal Aid, we are certainly saying to people, if you've got access to the internet, we really encourage you to have a look on the court's website. You'll see there's a drop down from the tab there with the word courts. It has a link for Drug and Alcohol Court, and on there you can find a number of helpful resources, including a lot of the information I'm giving, but also there's a lot of fact sheets and other forms that can assist you. You'll just see there I had mentioned on that slide about eligibility requirements, and just a couple there that, or three that are sort of, I guess, the restrictions in terms of drug court. So you can't be on parole or serving a prison sentence or charged with a sexual assault offence. The referral process, you'll see to the left of the screen there, there's a Form 1, and just as I mentioned, that court's website has copies of the Form 1. And you'll also see helpfully there, noting that a lot of you are with support agencies, that a support agency on behalf of a offender or defendant can help that person to complete this form, and perhaps either give it to them on their first court appearance or their next court appearance, or perhaps go with them to court and provide that, even if they don't have a solicitor or a duty lawyer helping them. So the referrals can be made, as you can see on that screen there, by a number of people, including that. But obviously, ultimately, you'll see the bottom sentence there, the participant or the defendant must agree for their case to be referred. So it can't be a case of a very well-meaning family member jumping up in court when their perhaps son or daughter appears in court and saying, please send them to drug court, and the offender's saying, no, I don't want to go there, thanks. So it does have to have the participant's consent. Now this slide perhaps might look a bit wordy, but it really is, again, something you might want to either print out or take away. And it's really just to give people like yourselves an idea of the pre-sentence assessment process. So even if someone fills in that Form 1 and asks to come to drug court, it's not a simple case of just, okay, they want to come to the drug and alcohol court. This is great, we'll take them, they'll get sentenced and they'll get an order. There's an assessment process that needs to be carried out, and this is because it's, I guess, a check and balance to make sure, one, that those referrals are appropriate referrals, and sometimes things can get missed, particularly maybe if you're in the arrest court and there's 100 matters and you might be a duty lawyer and you perhaps tick all the boxes, but maybe the client hasn't told you something that's correct. And again, if you're in a support agency and you fill in a Form 1 and think this is great, maybe your customer or your client hasn't told you everything, and so this is just a double check that we take as part of the assessment process. And the other assessment that carries on in drug court before a sentence is a risk assessment, which takes the form of a suitability report. So you can see there that the guideline, and the main one there perhaps is the second box on the top line there, and that's the case is assessed by 3 agencies. There are actually 6 government agencies that work together as a multi-agency approach to the drug and alcohol court. 3 of them are mentioned there. Obviously, Legal Aid is the 4th one, but there's also 2 other agencies, and I've just mentioned DJAG, or Justice and the Attorney General. They kind of oversee the program and also help to coordinate it. And also there's, of course, the Department of Courts, because the magistrate plays a very primary role in the whole of drug and alcohol court. You'll also see on the 3rd slide there on the top row, we have a cultural liaison officer. So that's been really, really useful and wonderful to have someone on board who is able to assist our First Nations participants or offenders to access the program and have that additional support to assist them not only with the routine of the order, but also perhaps engaging in and becoming more reconnected with family and extended family. You'll see it just mentions there about the risk assessment I've just talked about, or the suitability, and then you'll see the arrows go through to the magistrate then deciding at a suitability hearing whether the person is suitable, and then a sentence can be made. Once a person has a drug and alcohol court order, and as part of that order they'll have a treatment program, this is just a slide to show you, I guess, the mandatory requirements. So at the very beginning, you might recall one of the slides there was talking about the sort of commitments or routine that a person will have on a drug court order. You can see here there's some weekly, it starts off weekly mandatory requirements, which are a case management session, corrections, a counselling session, at least 3 random drug tests and a breath test, and a court review. Now, quite often, you'll have things in addition to those, and it might be that you need some outside counselling to address some other issues. It might be that you need to engage with a doctor or perhaps a detox facility. There might be a number of other things that you might have added to that, but that is, I guess, the real skeleton of a treatment program. It involves those things, which you can see reduce over time as a person progresses on the order. As I just mentioned, as I was discussing the previous slide, a treatment program can also include these education sessions, opioid replacement, as just mentioned, and engaging with the housing support agencies. As a way, I guess, to keep people on track who do the treatment program, the Drug and Alcohol Court has devised, with the leading, being led by Department of Justice and Attorney General, is a behavioural consequences framework. And really, I'm perhaps giving you a real screenshot or an overview of how it works, and it may look difficult, perhaps, if you haven't used it. But essentially, it's a way or a system to be able to assist participants to progress on their orders, because we do recognise that it is difficult. But in saying that, there's also got to be that accountability by people to really take ownership and responsibility of their progress on the order and keep wanting to achieve progress on the order. Or if there's no progress, being able to discuss what those barriers and challenges are. So that's the behaviour consequences framework and the need for it. So you can see there it just is basically a point system or a day system where an accumulation of 13, it says there, points or days can result in custody for a person. And my team, I think, pretty much worked it out that can't happen within 1 week. So a person could have a really bad week and it would be very hard to accumulate enough days to get 7 days in custody, but rather it would be something over the course of 2 or 3 weeks. So that really is that opportunity for the teams, for the participant or defendant, and for the magistrate to really look at someone who may have had a bad week on the order and go, hey, what seems to be the blockage here? What's the barriers? What can we help with? Is there something that agencies can do more to help you? Is there a different style of presenting to you or helping you to engage? Is there someone else we can maybe get on board? Is there another agency that might be able to help? And again, a lot of you being from agencies, I found really great to see, because Drug and Alcohol Court is always looking to try and know how many agencies out there might work with people who not only might be people you refer to the Drug and Alcohol Court, but by hearing what the Drug and Alcohol Court does, it might be that you want to look at engaging with the Drug and Alcohol Court just to say, hey, here I am, and I'm happy to help people who might have some needs in those areas because of their drugs and alcohol. You know, a lot of things in their life have fallen apart. So that might be where some of you can also reach out to offer your services or offer your agency contact details. So just to finish off, Drug Court, what our involvement in is lawyers. Our involvement is quite unique because we're not only lawyers, as you probably all know, in the traditional sense of sitting across a bar table from prosecutors and making submissions to a magistrate, but once people get on these orders or treatment programs, as I've mentioned, we play a role still with the participants, and that is ensuring procedural fairness, helping participants to adapt to their new routines, because the more help, the better is usually what I've seen. Explaining that consequence summary I've just mentioned and the behaviour consequences framework, and also assisting participants to discuss matters with a magistrate, providing general information, and helping obviously with family members and others. So there's just a brief summary, which is essentially what I've already talked about. And I guess the main box on this page is that Drug Court is accepting referrals. It doesn't and it won't close at this stage. It's referrals. So please, if you have someone who you think might be someone you wish to talk to us about, or you might want to recommend to them to contact us, I know it's a very lengthy email address, but there's an email address on there, or you could even just phone Legal Aid and ask to speak to somebody in the Drug Court team. Thanks.
Thank you, Penny. I'll just slide back on very briefly. Sorry that I'm a talking head. The next part of our presentation is about CourtLink, and I'll introduce Laura to now come forward and share that content. Thanks, Laura.
Thank you. So I'm going to talk about CourtLink, which is quite a different, if we can just go back to that previous one, quite a different program to QDAC that Penny's just talked about. It's got similarities in that it's also a therapeutic court environment, but there's some differences about QDAC being a sentencing program, CourtLink being a bail program, and we'll talk about that in the upcoming slides. I just wanted to start with this one though, because if anyone's interested in watching a simulation of the CourtLink in terms of what it's like inside the actual court, what it looks like, what happens, then this link is quite useful. It was done in conjunction with the Queensland Sentence Advisory Council, and if you're somebody who's watching who hasn't seen what it looks like in one of the therapeutic courts, have a look at that. It's quite interesting. So if we go on to what is CourtLink. So it's a voluntary bail-based program, and it's designed to help with a range of issues that can lead to offending. So similarly to what Penny was talking about with QDAC, the aim is to recognise that people have a number of factors in their lives which can lead to offending, and if we can address those factors, it might be that we assist their lifestyle that leads to that offending. But it's a bail-based program, so it's not that somebody has to even indicate that they're pleading not guilty or guilty or anything. It's simply a phase of their case, whilst other things could be going on in the background in a legal context. Effectively, for the participant, it goes on hold for 12 weeks while they address these issues. So CourtLink officers are able to provide case management for 12 weeks if somebody's accepted onto the program. They need to be having a moderate to high risk of offending in order to be suitable for the 12-week program. And if they are, a case plan is developed for them, and those participants are referred then into treatment and support services who are able to do brief interventions over that 12-week process. So if we look at what does that 12-week program look like, at the assessment phase, the CourtLink case managers are determining the level of support that's needed. So we talked on the previous slide about the moderate to high risk. If somebody's of a lower risk of reoffending, they can be referred to community-based programs by the CourtLink workers. And so that way they get some level of support, but not to the extent that they would get in the 12-week program, and not to that case management and case plan level. The aim is to avoid service delivery duplication. So sometimes it might be that even though somebody who we come across as lawyers in the arrest phase do identify as having needs that would lead to the CourtLink program, they might already be in contact with all those service delivery providers such as yourselves, and that may mean that the CourtLink workers determine that the 12-week program isn't needed for them because they're already in contact with the organisations that would have been referred to. So that's where they're aiming to avoid any duplication. The participants must be able to attend their appointments with CourtLink, and it can also include the referral appointments that they have. There's effectively no point in being on the program if someone's not committed to attending those appointments. And then ultimately it's for the court to decide if the defendant should be admitted to the program. If they do come onto the program, their progress is overseen by the magistrate at court every 2 to 4 weeks. Whether it's 2 weeks or whether it's 4 weeks can largely depend on how well the person's going and how much support they need. Progress reports are written by the CourtLink case managers and then provided to the participant. They're provided to us, to the prosecutor, to the magistrate, so that at that review we can all talk about how the person's going. We can see what their goals were, where they've progressed to, what's happening next. So the reports are strengths-based with therapeutic but honest progress made. And it's, as we've already talked about, a therapeutic court environment. So even if somebody's stumbling, the magistrate doesn't play that, I suppose, cliched usual role that a magistrate might of punishing somebody or of suggesting to them that that if they don't want to participate in the program, that the spot could be utilised by other people. That's pretty much as high as it gets if somebody's not going well. Magistrate is wanting to keep them on the program and wanting to motivate them to come back and do better next time. The magistrate provides encouragement to reach their case plan goals. So you have the situation where if somebody's going well, the magistrate will praise them and will talk to them about how that's helping them and how they're progressing in their lives. And again, if you watch that YouTube clip that was on that first slide, you'll see an example of what the magistrates do when they're speaking to the participants. So our progress reports come at every one of those review mentions. So we'll tend to have a progress report 1, 2, 3, and then a final report. We can have more common mentions. We can have them every 2 weeks rather than every 4 weeks, depending on how the participant goes. But in general, we'd have progress report 1, 2, 3, and final. And the final report's provided after they've done the 12 weeks. And it can be considered for any sentence. If somebody does go on to want to accept their charges and be sentenced within that court environment, they can be. If they don't want to be sentenced there, we can go on to have trials, and it can even include people who have district court and Supreme Court matters if they need to go on to the higher courts. Because it's a bail-based program, we're not limited by jurisdiction of the sentencing jurisdiction of the court. Limited participation can lead to being exited from the program, and there's no legal consequences for that. So we don't have a bail condition that says you must participate in CourtLink, and if they don't perform well, that we breach them. There's none of that. There's no legal consequences. So there's nothing to fear for anybody coming onto the program and giving it a try. If it doesn't work for them, exiting them, there's no detriment to them for doing that. And again, participants can choose to leave the program anytime. So if you have somebody who has been on the program before or is currently on the program, and they talk to you about being worried that they've got some further charges, as long as they're on bail for those new charges, then they can bring them into the CourtLink program to seek to have them join up with their CourtLink charges. And again, that's going to be up to CourtLink as to whether they still see them suitable on the program, and also the magistrate. But it is certainly possible and common to have people have some other charges early on in the program and need to bring them along. It's also common to have people who have come into the program and have charges which have predated the CourtLink program, but their first court dates are after they start. So we can join all those sorts of things up. There's also no limit to the number of times a person can attempt the CourtLink program, although it may be that there are some robust discussions at the assessment stage as to whether they have the willingness and motivation to come back. There's certainly not a limit, and that's largely because, unlike QDAC, which is a legislative program which has some rules about how that's going to work, CourtLink isn't. It doesn't have its own piece of legislation to govern it, so that we have quite a lot of flexibility in those sorts of things. So you can see in the blue box there all the locations that CourtLink's in. So it's in a lot more locations than QDAC. So it might be that as wonderful as QDAC is, if you've got a client that's, for example, in Mount Isa, they're not coming to Brisbane QDAC. So CourtLink might be a good option for people in those locations. You need to be an adult. You need to be on bail or applying for bail. So just that you can't be in custody, because then you can't interact with all the agencies that CourtLink wants to refer you to. You need to be charged with a criminal offence and appearing in any of the CourtLink locations. So we do have some civil matters that come through the courts, for example, domestic violence, where it's a domestic violence order. And I did see that there was a comment from somebody before we went into this process today, where there was a reference to having somebody in the DV courts. So if it's a DV criminal court, then it's a criminal matter. But if it's a DV civil court where those protection orders are being made, then they wouldn't come to CourtLink, because they're not actually charged with offences. They've just got some civil matters that they're sorting out. You can have your matters transferred to one of these courts if those magistrates allow. So if somebody's in a court where CourtLink doesn't exist, and they're able to get to a court where CourtLink does exist. So if I can use the example for Holland Park, for example, very close to the Brisbane courthouse, if somebody is in the Holland Park area and wants to come to CourtLink, they can transfer their charges to Brisbane for that purpose. The defendant needs to identify needing support on any of these issues, so drug and alcohol use, physical or mental health issues, impaired decision-making capacity, homelessness or risk of homelessness. So we have a referral form, like QDAC has a referral form, courts like forms. So this is a copy of that form with the link as to where you can get it, and referrals can be made by individuals, by family, by police, by lawyers, by magistrates. And the form isn't a barrier to accessing the program. So CourtLink's happy to assist by receiving referrals by email, phone, or a person coming in person, or coming to the courthouse. And of course, if you come and see a duty lawyer, we can fill out those forms with our clients. So Legal Aid's role in CourtLink, in some locations we provide a duty lawyer service. So in Brisbane, where I work, we provide the duty lawyer service to the Brisbane court. We provide 2 lawyers each CourtLink date, including a female lawyer, so that if there are clients who only want to see females, we have a female available. Duty lawyer service is for the day of court only, and most of our clients are very used to how that looks and how that works. But it basically just means that we see our clients on the day. We talk them through their report that they've been given, make sure we read that through with them, talk to them about any issues they might have. For example, if they've had a bad couple of weeks and they haven't been participating, talking to them about why, and being able to argue to the court to keep them on the program. Or if they're going well, to indicate to them that they're going very well, and that we'll talk about that in court. But then come the end of the day, that's our rollover with our lawyers until that next court date when we'll see them again. Representation from start to end, though, is where we have a grant of legal aid. So it may be that when we first see somebody, we say to them, oh, we really think you should apply for legal aid so that we can assist you in between court dates. That's really not going to be about the CourtLink therapeutic things. It's going to be about the help we think that they need with their actual legal case, and whether we need to be doing work in between court dates, such as negotiating with prosecutors, requesting evidence, those sorts of things. And that's where we sort of say, well, we don't want our clients to worry about those things in that 12-week phase. We want them to focus on the issues that they're getting assistance for, and as lawyers we can take care of that. So the difference between whether the first time we meet our clients as to whether we think they're in the duty lawyer service category or whether we think they're in the legal aid representation category is really to do with their charges and their criminal histories and what we need to do to assist them. If there is an application for legal aid, it will involve a merits test and a means test. The merits test is exactly about what I was just talking about. Is this something we can just assist them with on the day, or is this something which has gotten more complex and we have to assist them over a course of time to resolve their legal matters? And that's that merit. Is there merit in a grant of aid? And a means test, so they either need to be on Centrelink or a low-income earner. So the potential outcomes of CourtLink. So we've got the non-legal and the legal. So we've got engagement with treatment and support providers that can continue beyond the 12-week program. So many people have connected with agencies that they can then stay with through other forms of funding that agencies have. There's quality of life outcomes. People who finish the program are often expressing how much better they're feeling at that moment in time about their lives, being able to move forward and steer clear of offending. For some people, mental health treatment plans are in place. They get some encouragement, some assistance from the court and their CourtLink workers to put those into place. Housing options are explored or on the path to getting housing. Some people need help getting access to NDAS. Obtaining identification documents, which is a known barrier to making positive change. If you don't have identification, how do you get identification? So that's something that the participants will often be able to achieve in that program if they haven't got identification. If we get to a sentencing phase at the end of the process and they're placed on either probation or parole, there can be some handover to Department of Community Corrections. So although they are starting afresh with a new person, that new person can receive information about where they've been over that last 12 weeks. The completion of the 12-week program may be considered at sentence, and we often see a reduction in penalty. So it can mean that people who would have gone to prison at sentence are staying in the community on a particular order, or somebody who was going to stay in the community anyway, say on probation, instead of getting 12 months, might get 9 months because the court's just said, we've just done 12 weeks of a rehabilitation style program. And so there's a reduction in penalty that we generally see. It's not the motivation for people to come onto CourtLink, but as lawyers, that's something we'll advocate for at the end, that they have done 3 months worth of rehabilitation, which must be taken into account under the Penalties and Sentences Act. So we thought we'd do a CourtLink case study so that you can sort of see somebody's matter who's gone through CourtLink in a de-identified way, so that we don't identify that participant, but you can see what really happens to somebody who has gone through that process and what their outcome is. And I'll hand over to Kim to talk about that.
All right, so we had a young male who was referred to the CourtLink program a little while ago now, and he presented with needs around accommodation, substance use, mental health, and possible intellectual disability. So he had substance use related charges and domestic violence charges against his parents. He was already on a probation order at the time of his referral to CourtLink, but he wasn't engaging with his probation officer. He was seeing probation, or meant to be seeing probation, once a month, whereas CourtLink can offer that weekly case management with a person. So CourtLink contacted the probation officer. We had really good rapport with this participant, so he was engaging with us and engaging well. So we worked with the probation officer for them to come along to our CourtLink appointments with this participant, so that he wasn't having to go to corrections as well as to see us. We did those appointments together, and that really worked for this participant. So that demonstrates some of the collaboration and how we can support a person to meet their probation order requirements as well as get the benefit of CourtLink. So at his progress report at week 4, we were doing brief interventions with him around his substance use. So talking about his drinking with him and going through what he gets out of drinking and how he can drink safely. And we also did a relapse prevention plan with him. He wasn't willing to go to a substance use service provider at this point in time, and we really work with people where they're at. So we did these brief interventions, made sure he knew the services to go to if he was wanting to go to a substance use service provider in future. The reason why he didn't want to go to the substance use service providers at that point in time was because of his housing, his mental health, and possible intellectual disability. So he had a lot going on for him, so we prioritised doing those brief interventions around the substance use and working with him on the other issues. In terms of accommodation, we referred him to a youth service to support him around that housing support, as well as a specialist housing service in that location. He was couch surfing at the time of his referral to us. And as Penny said earlier, there is a real housing crisis at the moment. So we can't guarantee housing options, but we're certainly helping him along the way with his housing needs there. In terms of mental health, this person had a tendency to get quite upset with services, so we were working with him around managing his emotions, and so did a lot of work with him around that emotional regulation, particularly in relation to his mental health diagnoses. We also use the Eligibility Screening Index to screen people for possible intellectual disability. And that assessment told us that he did require a referral for a psychological assessment, which we were able to do, submit that referral by week 4. At week 8, so his second progress report, we continued with those brief interventions for substance use, and we had QCS also doing, the probation officer also doing those brief interventions with us and checking in with how he's going with that relapse prevention plan. In terms of accommodation, we supported him to complete a short-term housing application. While we're working on those longer term options, we work on some interim plans there with people. With the mental health conditions, we were continuing with the brief interventions around managing those emotions. And he also had a medication review, so we can do a health referral off to a GP, describe some of the things that are going on for the person in this health referral, so that that information is then transferred over to the GP. Sometimes we know people, when they're put on the spot with GPs, they're not necessarily able to communicate all of that information, so we're able to support people with that. By this second progress report, the psychological assessment had been completed. We were just waiting for that report. At week 12, at our final report, the participant disclosed a decrease in his alcohol use, which was really great to see, and we were definitely seeing that in his presentation as well. In terms of that accommodation, there was no outcome at the time of that final report. We were still waiting for that, but he was definitely on that path. And then in terms of the mental health and that psychological assessment, he did come out as having a formal diagnosis with attention deficit hyperactivity disorder, generalized anxiety disorder, and persistent depressive disorder. He was also assessed as having level 2 autism and got access to the National Disability Insurance Scheme. So that is a great outcome to be able to get that within 12 weeks. Some of you are probably aware of how long those processes can take. So we are able to speed those up with the support that we're able to provide people, which is really great. In terms of his sentence, so he was sentenced in the court-linked court that Laura was talking about. Prosecutions noted the seriousness of his charges with the DV charges and the substance use charges. Noted he was a young person and was building up a criminal history quite quickly in the adult space. He did have a pattern of breaches of bail and failures to appear as well, and that history that was consistent with the current charges that he was before the court with. Prosecutions also noted at the time of his referral to CourtLink he wasn't engaged with QCS, but also in their submissions noted that change and that he was now actually engaging and meeting his probation order, which was great to see. And also prosecutions noted the positive outcomes achieved with CourtLink, which is quite different to what you would typically see in a mainstream court circumstance. In CourtLink, we have prosecutors who are noting the positive changes for the person who's done the CourtLink program. Defence submissions talked really around the positive changes to the underlying issues through offending behaviour, including that engagement with QCS, and really leaning on the report that CourtLink did to talk about those outcomes. And they made submissions around that the defendant should be able to continue their rehabilitation in the community, and that extending that probation order was within the realms of because of his positive engagement with CourtLink. In terms of sentence, the magistrate actually read the CourtLink report out aloud in court, noting his high level of engagement, his positive outcome with getting that formal diagnosis and the NDIS support, and the magistrate said that he had laid the foundation for genuine improvement in his life. So that just gives you a little insight into how sentencing in CourtLink is different to what you might see in mainstream court. The participant was sentenced to a 12-month probation order, which would extend the current probation order that he was under at the time of CourtLink by 5 months. If it wasn't for engagement with CourtLink, he would have received a sentence of imprisonment. So we can see there the benefit that people get out of doing the CourtLink program. So we're working with people with this external motivation of potentially getting that better sentence outcome. Whilst they're with us, we're working on that internal motivation to make those positive changes in their life. So up on the screen there, just notes where you can find the information on the court's website. So it's on the same page where you can find the drug court information, but there is a drop down for CourtLink there on that court's website. We are more than happy to come and do presentations to any service providers, so please reach out to us at any of our sites and we can come and talk to your staff. And just the last point there, we have just been evaluated by Deloitte over a 4-year period, and over that time the Deloitte report notes that we reduced recidivism or reoffending, and the frequency and seriousness of offending was reduced for people who had done CourtLink, and the time to reoffend was longer for those people who did CourtLink, as well as all of the other quality of life outcomes as well. So that is published on our court's website now. It's a nice long report for everybody to read, but it's really demonstrates the positive outcomes of CourtLink.
Great, thank you. I'm just going to swing back into view. Catherine here again, the talking head. Thank you, Kim, and to Penny and Laura, our presenters, for sharing that information. I hope you all found that really useful and helpful and relevant. I will just remind you that we will be taking questions now, so please feel free to enter them in the questions tab on your screen and we'll ask those of the presenters. I'm just having a quick look at the tab now to see what ones have come through.
Can I also mention?
Yeah, sure. Sorry.
I just wanted to mention that someone earlier before the talk had asked about, can you refer more than, or is drug court just taking drug charges? I just wanted to clarify, because we could talk for 5 hours about drug court. There's so many different ins and outs of it. In terms of the eligibility requirements, really most people come to drug court with property offending rather than actual drug offences, because it's, again, looking at offences that have been contributed to because of drug and alcohol issues. So it's not just actual drug charges, although a lot of the participants do have possess dangerous drug type offences and possess utensil and fail to dispose of syringe, but they also have charges which are predominantly enter dwelling, stealing, theft, receiving type offences. So just to cover off that point. And the only other thing I wanted to mention is that we're all sitting here together because CourtLink and drug court work really well, I guess, hand in hand, and sometimes we'll get a referral to the drug and alcohol court which we consider might be more suitable for CourtLink, and vice versa. So there often is the should we say, interchange of people depending on that level of seriousness, and perhaps if they are looking at sentencing, it might be they go to CourtLink and then come to the drug and alcohol court to continue that, because they might still be looking at a sentence of imprisonment, which is really the key thing for the drug and alcohol court, being at the perhaps other end of the scale. In terms of CourtLink, obviously taking anyone whether it's guilty or not guilty, but in terms of seriousness, you know, the drug and alcohol court is looking at that person who is facing imprisonment for their offences. Thanks, Catherine.
Thank you, Penny. So I'm just checking the questions tab. We've had a couple of questions come through. The first one is the 12-week time frame long enough for all clients? Could you see a benefit in expanding support for a longer period?
Yep. So I'll respond to that one. Yeah. So we are a short program, but we want to be a nudge in the right direction for people. And we want people to continue on with those services well after the 12 weeks has finished. So it's that opportunity pre-sentence to provide that support to someone and have that motivation to keep going with that reinforcement at that sentence time. We don't think we're going to necessarily turn someone's life around in that 12 weeks, but we want people to be on that path to be making those positive changes in their life.
The same person also asked, what is the capacity of CourtLink? Could it be expanded?
So one of the recommendations in the Deloitte evaluation is around expansion, and that is a decision for government around whether they take up that recommendation.
On a positive note, it has expanded since it first started.
Yes,
we've had sites added over the years.
Yeah, so we started in Brisbane in 2017 and then rolled out to our other sites, with Pine Rivers being our most recent site at the 26th of March 2023.
Great. Does CourtLink employ lawyers? That's the next question.
So all of our staff are PO3 levels, so they are experienced case managers, and they do need to have those human services degrees. So that can be social work, criminology, psychology, so really that kind of helping degree, so we don't take people with straight law degrees. Some people might have law degrees as well as some of those human service degrees, and we will look at those in terms of applications.
Great. The next question is QDAC going to be available in more areas outside of Brisbane? If so, when? Oh, Will's jumping on screen. Sorry, another person to join us. Just bear with us while he just comes.
Hi, everybody. Similar to CourtLink, we're in the process of evaluation, so hopefully wrapping up soon, and then we'll know recommendations. And again, it will be a matter for government to consider any recommendations for expansion. But at this stage, no, that we commenced in 2018 on the back of the Drug and Specialist Courts Review. That recommended that we exist only in Brisbane at this stage and really embed our practices and be evaluated before any expansion. So at this stage, hopefully in the next few months, we'll have an evaluation released publicly.
Probably in a similar trait, and there's another question about how do these programs assist people in regional areas given the residing restraints around QDAC and the location of the CourtLink assistance. Are there any examples of regional people being able to access these services?
So as Laura said in her presentation on CourtLink, if people, for example, reside in Cloncurry, but they have charges in Mount Isa and they're planning to move to Mount Isa and those charges can be transferred, which is a decision by the court, we're happy to consider that there. If a person, for example, in Cloncurry has charges in Mount Isa and isn't able to get into Mount Isa for the benefit of CourtLink, the CourtLink program there for case management, we will offer a community referral into those locations that they do live. So that it's just around where those matters are in those CourtLink locations in those courthouses. We do have our drug and alcohol diversion programs that are available in every magistrates court and children's court across Queensland, and they are really a brief intervention for people with substance use or substance use related offending. But that would be a whole nother webinar to talk about those programs, but there is information available on the website around those. So if someone is ordered to do illicit drugs court diversion program or drug and alcohol assessment referral, which is those two programs that I was talking about, they can do a 60 to 90 minute session with a substance use service provider. And that is managed through Queensland Health, and those service providers are available all across Queensland. They can do those sessions by phone or in person, and we do have those sessions available on the weekends as well to support that access to those programs. If the person completes that session, then they can end up with no conviction recorded. So they are some options that are available in all magistrates courts across Queensland and children's court.
Can I just say for the drug and alcohol court, that any magistrates court in Queensland can refer to the Queensland Drug and Alcohol Court, and that really means, obviously some people might say, well, how could you do that if you're in Mount Isa? But if you're in custody in Mount Isa, which means you're probably in Townsville Correctional Centre or somewhere, if you, as I mentioned about the referral criteria, if you live in the Brisbane greater area or intend to reside, so that's the key words there, intend to reside. So any person in any custodial centre in Queensland is in fact technically eligible if they say, I put my hand up to want to reside in the Brisbane area to be able to access the drug and alcohol court, because perhaps I need to move away from the area I'm in because I know too many people who provide drugs and alcohol to me. So we have had people from as far north, I think it's from Lotus Glen. We had someone referred who was in Lotus Glen Custodial Centre. We regularly have people in Maryborough Custodial Centre, from Woodford. So because, again, we're dealing with people in the drug and alcohol court or otherwise looking at imprisonment, we do have a large number of people are referred to the drug and alcohol court who are in custody already on remand. So although that the drug and alcohol court isn't in every region, unfortunately, in Queensland, there is still a way of accessing it if you do live outside those areas.
Thank you, Penny. One very, very quick last one, because we are at 3 o'clock. Does QDAC allow DV offenders to participate?
Well, when you say, it's kind of like what Laura had said earlier about DV offenders. So if the person has a contravened domestic violence order offence, yes, that is not a disqualifying offence. That person can be referred to the drug and alcohol court. And you would have seen on that slide that I referred you to that had about 8 boxes on it and a bit of an arrow with the process. That part of that suitability and risk assessment that I had mentioned is really, I guess, the key, because maybe if they've got, say, 6 contravened domestic violence order offences, it might be that there's a risk factor there that the drug court has to consider in terms of their suitability for the order. But we have had people, we do have people on orders who've got common assault, contravened DV offences, because a contravene can also be something like going within 100 metres of a person that you weren't supposed to. Doesn't necessarily, just because it's domestic violence, involve a violent aspect to it. But certainly there's also access on the order through corrections to the Men's Domestic Violence Program and other programs. And could I just quickly mention, and before a lot of you obviously need to sign off, that there's another program in the specialists courts purview, which is the Murray Court. And that, when I mention about other courts that we sometimes interchange participants with, that's the other court also that we've had some First Nations participants come over to drug court and perhaps also to CourtLink, but also that we refer to if someone is referred to the drug and alcohol court and it seems like the Murray Court might be a better option and they decide it might be a better option for them. So just giving them a shout out.
Great. Thank you so much, Penny. So I'm going to wrap this up super quickly. On the screen now are Legal Aid's contact details. If you have any clients or you want to talk to Laura or Penny or members of their team about clients you might think would benefit from taking part in those programs, please give us a call on the first 1300 number. We also have a dedicated phone line for Aboriginal and Torres Strait Islander people. It's a priority phone line, so that's the second number there, 1300 65 0143. And for people who've submitted an application for legal aid, that third phone number is the best phone number to call for them. On the Legal Aid website, there's heaps of great free legal information. We've got lots of publications, guides, fact sheets, videos about a whole range of common legal problems. So I'd encourage you to go to the Legal Aid website, which is listed there, and click on Find Legal Information and then Publications and Resources. All of these can be downloaded or ordered and delivered for free to your organisation. So please make use of that resource. We do run these webinars monthly. Next month, we're just finalising the date for the webinar, but it will be as part of Domestic Violence Prevention Month. It will look at young people and healthy relationships. So once that's all confirmed, we'll send around an email to let you know and register for that one. This webinar that we're doing today, that will be captioned and uploaded to our YouTube channel. So you're welcome to rewatch that then, and we'll send a link to that round as well. If you don't already, please follow us on Facebook, on LinkedIn, on Instagram and X for promotions about upcoming webinars and new resources and information leaflets that we produce. And that is the end of our presentation today. Thank you so much for joining us, and please, hopefully we'll see you at the next one. Thanks very much. Bye-bye.